Okay, I'm hoping that you listen to the video and watch the PowerPoint about copyright. That's something very important. And so we're going to, that was part of intellectual property. We're going on to the second part, which deals with patents, trademarks, and trade secrets, um, all of which go under the topic of intellectual property. So if you open up, I'm sorry, that PowerPoint and read along with me. Uh, we've got a little bit of comparison here in the first slide so that you don't confuse copyright with industrial property protections. So that's what patent covers, industrial property. Um, Copyright is part of intellectual property. So, copyright protects literary or artistic works, whereas patent, trademark, and trade secret law protect what we call industrial property. Industrial property encompasses all digital media devices and products in addition to the words and symbols used to market them. So you would have a patent on an iPod, a patent on a tablet, a patent on a computer, or what makes up the computer and that sort of thing. You would not have copyright on it. Patent, trademark, and trade secret laws are commonly lumped together, but the three are separate and distinct from each other, and I hope that you will be able to understand what those distinctions are. According to Richard Stallman, quote, they originated separately, evolved differently, cover different activities, have different rules, and raise different public policy issues. So, as you can see, they are very different. They're different in every way. Uh, so, here we talk about patent protection. Lasts for 20 years from the date of the application. And there are three basic types of patents that I want you to remember: utility, design, and plant. Yeah, I know, plant is the odd man out. Doesn't sound reasonable, but yes, it is. Utility applies to the invention or discovery of, quote, any new and useful process, machine, article of manufacture, or composition of matter, or improvement thereof, such as an iPhone or a Kindle, or you come up with something new or substantially newer. Design patent applies to new, original, and ornamental design for an article of manufacture. Example, if you've never seen a Movado watch, it when it came out, it really hit people because it's so striking. It is strikingly simple. It's got basically a blank face and just the short and the long hand. There's nothing to indicate where the 10 is or the 7 is or any minutes in between. It's just the small and the large hand, and everything else is blank. Then a plant patent applies to an invention or discovery and asexual reproduction of new kinds of plants. For example, seedless watermelons. I don't know how they did it, but I'm sure glad they did it because I can't stand the seeds. I love watermelon, can't stand the seeds. Just remember that that is covered under patent protection, but it's plant patent protection. Okay, so here are exceptions. There are exceptions to every rule. Exceptions to patent protection. Laws of nature. You can't patent a law of nature. Natural phenomena. A law of nature could be gravity, okay? Natural phenomena could be hurricanes, tornadoes. You can't discover such things. And abstract ideas such as freedom, Um, what other kinds of things? Well, that's what's hitting me right at the moment. Freedom. Um, so here we have the basic rules about patent protection. Unlike copyright, which is automatic, after you make that last brushstroke on a painting, it's copyrighted. Patent protection is not. You must file for it. You must register through the PTO, which is the U.S. Patent and Trademark Office, to acquire protection. The invention or discovery must meet 3 criteria. It must be novel, it must be useful, and it must be non-obvious. I I know it's funny when you see something new and you say, "Oh, gee, I could have invented that." Well, did you? Did you invent it? Well, maybe it's more non-obvious than you think. So we have an act that happened in 2011. Excuse me, I've got allergies. Oh, I don't wear a mask right now because there are no living creatures in this room with me. But when I leave this room, I put my mask on. America Invents Act of 2011. It changed the awarding of patents from a first to invent basis to a first to file basis to be consistent with the way other countries filed patents. It was also very difficult to determine who was the first to invent it. We have a lot of these things happening. If you look into the 1880s, 1890s, we have lots of different things being invented. And many times you have somebody like Edison working on something, and you have Tesla working on something. You have several people coming up with the phonograph or the camera. So we don't know who's doing what when. So the first person to make it to the patent office and actually apply for it, that's the person who gets the patent, if it meets all of the regulations. The change in this was intended to encourage inventors to seek patent protection in other countries to market their inventions abroad. This was it's almost 10 years ago, but the thought was we need to be competitive abroad, so we need to be able to compete with them, so we need to patent our inventions, industrial property over in other countries. It created a fast-track option for new companies to shorten the normal wait, which was 3 years, to 12 months. Well, that makes it takes 2 years off of the process, which is great. If you've ever looked at something like a tube of toothpaste and you look close enough, you can see where it says patent pending and then a long number. That's basically where they are in line to get it patented. It's pending. They've applied for it. This means stay away. We've already applied for this patent, so go patent something else, not this. And then on 7, so what are the infringements? What are the remedies if somebody infringes on it? Infringement applies to, quote, whoever without authority makes, uses, offers to sell or sells any patented invention within the United States or imports into the United States any patented invention during the term of the patent. No statutory provision for fair use. Remember, in copyright we have fair use. It's kind of it's a gimme. It's a period of time when you can do something. You can actually you're almost infringing on the copyright, but they give you what is it called in golf? It's a gimme when you do a putt, but there's when you hit a terrible drive. I'm trying to think of what it's called. At any rate, patent infringement is a civil violation tried in federal court. It is remedied by an injunction to stop the infringement or damages if the plaintiff has been harmed. So if you end up infringing my patent on a particular device, and lo and behold, somehow you do a really great bang up job of marketing your product and you beat me in the marketplace, wow, I can sue you for everything you've made from that stolen patent. All right, we're going to stop it right here.